Welcome back to Organized. I'm Professor Seth C. Oranburg, and we're going to continue studying shareholder litigation. In previous episodes, we've talked about how a suit proceeds all the way up to trial, including how we get the discovery that tells us whether we can resolve it without a trial. Now we're going to assume that we can't. For some reason, summary judgment failed, and so we're moving to the real resolution phase, trial, as well as looking at settlement and alternative dispute resolution in shareholder litigation. This is actually not the most important thing because although it's the end game, most cases never make it to trial. Most cases settle or use alternative dispute resolution instead. So part of what we'll do here is not just talk about the civil procedure of shareholder litigation at trial, but we'll explore why we don't have them. And we'll take a look at some of the post-Zuckerberg developments. That's the 2021 Zuckerberg case that had the three-part test for director independence and demand futility. Those developments have made derivative suits tougher. This phase is crucial for addressing agency costs because settlements in ADR often realign manager incentives with shareholder interest without the full cost of litigation. And the threat of a trial sometimes keeps people in line. So look, trials are the dramatic endpoint you see in movies, and many law students went to law school because they were interested in trial practice. It's not surprising because that's the part you see on TV. But if you become a corporate lawyer, this is not what's going to happen to you in most instances. Very, very rare does shareholder litigation go to trial. Less than 1% of shareholder litigation cases go to trial. So why? Well, one is they're expensive. Trials are time-consuming, and trials are risky. And why would you take on risk if you had the information to make a risk-adjusted calculation on value that can result in a settlement? But in a trial, you'll present your case to a judge or jury with opening statements, witness testimony, cross-examination, evidence, and closing arguments. In direct actions, you'll have to raise your securities fraud claims, and juries will decide facts, like whether a statement was misleading. In derivative actions, the Delaware Chancery typically has bench trials. There isn't a right to a jury in Delaware, and judges rule on fiduciary breaches as a matter of fact, even when sitting on the bench. But if you're dealing with securities claims in federal court, you might have a jury of 6 to 12 people deciding on whether or not a representation is material. And this could be a very complex technical issue that would be hard for an average person to understand, adding a lot of risk to that kind of decision making. Or even more urgently, we should call it uncertainty, because you really can't calculate how that particular group is going to come out. Both parties want to avoid this in many cases. And post-2021, Zuckerberg, which changed the standards for whether directors are able to decide whether a case should proceed, derivative trials are even rarer. The three-part futility test strengthens directors' defenses and pushes more toward early dismissal. But if it reaches trial, the plaintiff will have to prove substantive violations. Trials enforce accountability, but at a very high cost, and so they are very rare. Which turns us to our more common substitute, settlements. Settlements are actually the most common resolution. Over 70% of shareholder suits end with a settlement. A settlement is a negotiated agreement when the company pays money, changes practices, or both, and in return, the plaintiff drops the suit. So why settle? Well, let's go back to why not trial. How about predictability? We can avoid the risks and uncertainties of trials, especially with juries, which could award huge verdicts or nothing. In direct class actions, settlements often include cash for the affected shareholders. In derivative actions, it often involves governance reforms, like better oversight to prevent future agency problems. After discovery or motions, parties often bargain, often with a mediator. Courts approve these bargains to ensure fairness, especially in class action suits. Companies have a lot of leverage in derivative claims now. They have stronger abilities to prove that there was a ability for management to act, which means it's harder to show demand futility, which means better settlement terms for management. Moving on to our third possibility, we could have an alternative dispute resolution, like mediation or arbitration. And these are increasingly popular for faster private resolutions, especially in cases outside of Delaware. Now, again, Delaware is known for having specialty courts that are particularly good at resolving issues comprehensively, efficiently, and fairly. But if you're in a different jurisdiction, ADR starts to become more appealing because you can then ensure that you have a neutral third party who has training on the particular issue and may have subject matter knowledge. It also can keep things private, so you don't have all the exposure that a court case is going to have. Now, there's different kinds of ADR. Remember that mediation is non-binding. It's great if you can arrange a collaborative fix. It's the least expensive. It can be very, very quick, but it is non-binding. The parties don't have to do what the mediator suggests. Arbitration, on the other hand, is binding. A binding decision by an arbitrator can be mandated by things like bylaws. And in a shareholder context, these ADR suits reduce cost, which can often get us to a better result where more value is available to the company and to the shareholders. The challenge, of course, is that if mediation fails, the parties might harden their positions and might retrench themselves. And arbitration can lack appeal because some might see arbitration as favoring industry. But again, there are benefits like lower costs and confidentiality that can be preserved in these ADR techniques at the end of our shareholder litigation process. Trial is really the answer if all else fails. Let's illustrate this with a hypothetical in a direct action. Suppose a misleading disclosure suit survives the early motions process. At settlement talks, the company might offer a cash award for the class of affected shareholders. And the shareholders might also negotiate for reforms like better reporting practices to prevent future issues. This would all avoid the uncertainty of trial. But if no deal emerges, you might move to mediation, or a neutral third party might suggest a compromise. And if that's possible, the parties might agree to settle the case. Usually, if they've gone this far in the litigation, they would not then move to ADR, but it could be that parties opt for that from the beginning. In fact, in many cases, ADR is required based on bylaws for certain types of breaches. For a full trial in a direct action, you would see presentation of very strong fraud evidence because almost certainly it would have survived a motion to dismiss and a motion for summary judgment. The judge will hear the witnesses testify, and then they rule on liability. And in fact, the jury might hear the case because oftentimes these will occur in federal court where there's a right to a jury trial. These are really rare, as the risks involved and the uncertainty and how a group of 6 to 12 people will deal with very complex corporate financial issues often pushes parties to settle instead. But these examples show how resolutions are meant to balance accountability with efficiency. And again, trial happens if all else fails, but the settlement and ADR dominate the practical fixes. In our next episode, we'll look at some emerging trends like digital tools and regulatory shifts. Until then, this is Professor Seth Oranburg signing off.